Please be seated. Please be seated.
Hey, Agent, if you'll come back. Agent Stewart. And you can bring the jury.
All jurors present, Your Honor.
All right, thank you. You may proceed.
Mr. Stewart, we have the unenviable task of talking about DNA shortly after lunch, so we'll try to get through this in a relatively short manner. And what I would like to do in order to help the jury understand the processes that you undertook is to allow them to see the items that you evaluated. So I'm handing you what has been previously marked for identification as Defendant's Exhibit 26. Do you recognize this document?
Yes, I do.
And is that a document that you authored or approved?
Yes, it is.
Okay. I'd like to ask you just a couple of questions about that. the date on that is the 13th of April. So you had several different reports and updates, as I understand it. Your initial report was on the 6th of April, correct?
Yes, that is correct.
And then it was updated, I believe, on the 13th of April with additional information from the buccal swab from Michael Slager, correct?
Yes, that is correct. I'm sorry, I want to also correct. My first report was on April the 8th. I apologize.
Okay, that's good. And then there was one more supplemental report after you evaluated some, I think, some probes that were sent to you for DNA evaluation, perhaps in August. Is that correct?
Yes, that report is dated September 1st.
Okay. So just for our purposes in the relevant items here, we're going to work off the April 13th, 2015 DNA analysis, okay? You have a copy of that?
Yes, I do.
Okay. And could we show the jury page 1 of that report? Okay, so just to be clear, it's labeled a supplemental report because you got more information from the initial report that you did, is correct?
That is correct.
Okay, and just the format of the report very quickly, you list the items that were submitted to you for your analysis and then the results of your examination, correct?
That is correct.
Okay, so let's just run through these very quickly. And the first one was items, and by the way, these items are your numbers, not the SLED numbers, correct?
No, these are the SLED lab numbers.
But they're not the crime scene numbers. They're the numbers that the SLED lab adopts when it comes in, correct?
That is correct.
Okay, so we have number 23, swabs of red stain from officer's shirt. And I believe you testified earlier that those swabs were delivered to you and you analyzed it for DNA, correct?
That is correct.
And then 24, the same item, a swab of red stain from officer's pants, you analyzed that for presence of DNA.
That is correct.
And in neither of those did you get a swatch of cloth, you just had the swab that you analyzed. In other words, they didn't cut a piece of pants or shirt out, they just gave you a swab and then you performed your analysis based on that.
That is correct.
Okay, and then number 25 and number 26 are both swabs from Taser cartridges, correct?
That is correct.
And moving on to page 2, you had item 27, swabs from Taser. Item 28, the blood spot card from Mr. Scott. Item 29, envelope with fingernail clippings on the right hand. Number 30, envelope with left fingernail clippings. Number 31 is one envelope with pulled scalp hair from Walter Scott. And then we have number 52 here that says buccal swabs from Michael Slager. That entry is in bold. Can you tell me why that entry is in bold?
Yes, that indicates the item that was new to this report, the supplemental item.
Okay. And I noticed that you performed DNA analysis on all of these items except for item number 31. Can you tell me why you didn't test item 31, which is the pulled scalp hair from Walter Scott?
Yes, item 31 was an alternate known standard for Walter Scott if I was unable to develop a DNA profile from the blood spot card.
Okay, so that provides you a different means, an alternate profile. What about the fingernail clippings? Would that serve the same purpose?
It can, but we would prefer either buccal swab, blood, or hair as an alternate known, as a standard, I should say.
Okay, and then at the bottom of page 2, you say that, could you explain what that sentence means under examinations?
Yes, the statement DNA analysis was performed on items using short tandem repeats. Those are the STR locations that I stated earlier, and that's the process we use to develop the DNA profile. And as I stated, it's 16 different STR locations.
Okay, for lack of a better metaphor, those STRs would be like places on a map, perhaps, and certain genetic information, when you analyze it, might show up at those places on the map?
It should, yeah. In a sense, yes, we could say that.
And the reason you use those 16 places is that there's a lot of commonality amongst the human race for people who would have markers at those spots. Is that correct?
That is correct.
Okay, when you perform the examination on page 3, we have results, and I believe you've gone over most of this already. I just want to go over it briefly. Item number 24, which I believe is the swab of red stain from officer's pants, you said matches DNA profile of Michael Slager.
That is correct.
Okay, and likewise with item number 23, with the exception that item number 23 also had a minor contributor that was insufficient for you to analyze?
That is correct.
Okay, item number 27 is the Taser, and you said it's a mixture of 2 individuals, correct?
At least, that is correct.
And it says that Walter Scott and Michael Slager cannot be excluded as contributors, right?
That is correct.
Can you explain to the jury what cannot be excluded means in terms of identification?
Yes, when I'm looking and comparing their DNA profiles, Walter Scott and Michael Slager, and I'm comparing it to the DNA profile from the mixture, as I'm doing my comparisons and looking at every location, I'm unable to exclude them as possible contributors to that mixture.
Okay, I'm going to hand you an item that's been previously marked for identification as Exhibit 28. Do you recognize this document?
It appears to be our DNA operationals manual that is dated May 30th, 2014.
And would that be the general handbook that you would use for guidance in your daily tasks?
Yes, possibly at the time. We've had revisions and we have updates, so I'm not sure if this was the latest manual that we're using at the time, but it is one that we were using at SLED at one point.
Okay, let me ask you just one more question about the contribution of DNA and exclusion and inclusion. If you could turn to page 131 in that manual. And the second paragraph down, I think, says, in general, for interpretation, conclusions are possible. Is that what you're reading?
In general, for interpretation, conclusions are possible?
Right.
Okay.
So when you said that Walter Scott and Michael Slager could not be excluded, that is actually an interpretation of inclusion, isn't it? According to the definition. In other words, you can make a positive identification. That's known to SLED as a term of inclusion, that they couldn't be excluded. That's a positive statement that there's something on there. They can't be excluded, but it's not a DNA match. It's short of a match.
Yes, that is correct.
Okay.
We only match the single source single source profiles, I should say.
But there is a relatively high degree of confidence when someone can't be excluded. You're confident enough that SLED terms that a term of inclusion.
In a sense.
Okay. I know that sounds a little confusing, but I just wanted to make sure that we understood that. Back to the previous Exhibit 28 on page 3, the DNA profile from 29 is a mixture of at least 2 individuals. And 29 is fingernail clippings from the right fingernail, is that correct?
That is correct.
Okay, and you could develop a major contributor and a minor contributor profile for that, couldn't you?
Yes, I was able to.
And could you explain to the jury what constitutes a major contributor and a minor contributor for the purposes of this forensic examination?
As I stated earlier, a major contributor is an individual who contributed more DNA to that item. And we use a criteria to be able to determine that major contributor within that mixture.
Okay, and so it's not just who contributed more, but it's actually a term of art. They have to contribute more to a mathematical degree in order for you to consider them major and minor, right? Some 60% higher readings?
Yes, for every number at the locations, that is correct.
Okay, and so if you don't have more than 60% higher, you can't identify a major contributor and a minor contributor as they're known forensically.
At a certain location, we may have peaks, or I should say numbers that don't fall within the 60%, but we'll have to look at the whole profile of that mixture. And depending upon how many locations I am able to determine a major contributor, that's what I would base it on.
Okay, and you said peaks. The peaks are just sort of small measures of the quantity of DNA, is that correct?
With the quantity for each number, I should
Right.
say.
And those quantities of DNA are not measured in a unit that we're familiar with, right? The quantity that they're measured in is a scientific nomenclature, correct?
That is correct.
And what's the name of that nomenclature?
It's RFUs, which stands for relative fluorescence units.
Okay, so while we're talking about relative fluorescence units, could you explain, just very briefly, the process you go through physically to be able to determine those quantities? So what do you do with your DNA sample in whatever machine you have, and then what sort of output do you get to make these determinations?
When we have the samples, I guess I'll start. After quantification, we do what is known as PCRs, which is known as polymerase chain reaction. And what we're doing is making multiple copies of that DNA. Once we have the copies at a certain range, as I stated earlier, because of the quant value, we have an instrument. It's called a CE, or capillary electrophoresis. And what we're doing is that we're trying to find out how much DNA is there within that sample using fluorescence. So the sample is ran through our electrophoresis. Based on the amount of relative fluorescence that comes from those samples that are ran on the CE, or the capillary electrophoresis, we're able to give each number a relative unit, a relative fluorescence unit. This is how we judge the peaks for each number. So, so using those numbers, we're able to judge the DNA profile for every individual for each location.
Okay, and given those numbers, how do you go about comparing these one to another then? For example, is there a way that you identify these spots, these markers on the DNA, or pardon me, on the samples that you get? So you have your 16 STRs. How do you identify what goes under each little place there, each little STR?
The instrument splits it up between the different locations for that whole profile for us.
And these numbers that you get are essentially based on some repeating configurations, right? How many times they repeat?
Yes, that is correct.
Okay. And could we take a look at page 5 of the report on the 13th? Okay, that's a little bit hard to read. Could you blow up the, say, the left 3 columns or so? Okay, we'll take a look at this. Under This is entitled Identifier Plus. Is this a report that's generated by the equipment you use?
No, we use a system that we have, a beast system that we use to generate that report.
Okay.
But it's input data from the instrument that we use.
Okay, so under item 28, which is Walter Scott, you have some different columns here. Now, those columns represent the 16 STRs you were talking about?
Yes, those are the 16 different STR locations.
Okay, and then the number there, 1415, what's the significance of that?
As I stated earlier, we receive half of our DNA from our mother and from our father. So at every location for each individual, you have either one number or two number. One number is one that you got from your mother, and the other one you have from your father. If it's just one number there, that means that both your mother and your father donated that same number at that location for you.
Okay, and those numbers, those configurations of genetics, like you said, help us, they form who we are essentially, eye color, hair color, things like that, correct?
Yes, DNA genetically can do that.
Okay, so let's look at the second column down. It has Michael Slager at the same spot, and those numbers are 9 and 10?
Yes, so at D8, that location, he is a 910.
Okay, let's look down to item number 27, swabs from Taser.
Okay.
And could you explain those numbers?
So as I stated, item 27 was a mixture of at least two individuals. So at that location, D8, we have a 9, a 10, a 14, and a 15.
And because Walter Scott has a 14 and 15 at that location, and because Michael Slager has a 9 and 10 at that location, that's what leads you to believe, amongst other things, that they could not be excluded from the person or persons who provided that DNA. Is that correct?
So yeah, so essentially what I did was I went at each and every location for item 27, and I compared that DNA profile, that mixture, to the DNA profile of Mr. Walter Scott and Mr. Michael Slager, and I compared it at every location to see whether or not I had correspondence of their different numbers for each location.
Okay, and that led you to conclude that they couldn't be excluded as contributors to that mixture on the Taser?
By looking at every location, that is correct.
And the percentage or the statistics on that are a little bit different than the statistics on an individual who is included, right, who's been identified by DNA.
Yes, it is.
And the reason for that is just statistics, right? There's more people who could meet those 4 markers than there would be a person who could meet just 2 markers. Is that correct?
Well, it's because we're dealing with, I should say, less information when we have a single source compared to a mixture. When we're comparing a mixture for individuals, we have more possibilities. So because of their greater possibilities of an individual being included, or not being excluded from that profile, that means that the stat will go down because more people can be included.
Gotcha. Okay, I'm going to show you what's been marked for identification as defense exhibit 27. You recognize that document?
Yes, this is my case file for this case, but I'm not 100% sure if it's the full case file.
And let me tell you that it is not a full case file. It does not contain the addendum that was provided for the Taser probes for which you rendered a report on the 1st of September.
Okay.
So this is the basic report that came out. And what is contained in this report?
So the case file has all of the work that was completed to help develop the DNA profile. So it has the submission from the agency. It has all of my worksheets that I used during the process of developing a DNA profile. my extraction, my quant, when I ran it. So it has all that information regarding the work that was done on this case.
So this is the meat of the work that you did on the case, correct?
That is correct, for this portion of
Right.
it.
Okay, let's take a look, if you would, at page 43. And could you explain to the jury what this represents?
So this is the raw data that is given to me from the instrument. So these are the different numbers with their peaks and their RFU values, their relative fluorescent units. So by looking at this, I go through it to determine, do I have a mixture? How many people do I believe are contributing to this mixture? And then once I make those determinations, I can go forward with trying to make a comparison. I also, before I even do that, I also determine which locations I believe are appropriate for a comparison.
Okay, so if one were to figure out a major-minor contribution, let me ask you this. What is item number 27, do you recall?
It is the swap from the Taser,
Okay.
swaps from the Taser.
Okay, so if one were to determine a major-minor contributor, this would be a means of doing it, is that correct?
Yes, this is what I use to determine the major minor, or if there's a major minor, I should say.
Okay, so as you recall from the last slide we looked at, let's just take the first point, the first STR. Michael Slager was a 9-10 at that point, correct?
That is correct.
And Walter Scott was a 14-15 at that point, correct?
That is correct.
And the height of the peak represents the quantity of DNA, is that correct?
Yes, for that number, I should say yes.
Yes, for that particular location.
Yes, that is correct.
So would you agree that the peaks of 15 and 14 are higher than the peaks of 9 and 10 at that point?
Yes, those are higher, but as I stated earlier, I have to look at the entire profile. And by looking at it, I also see that 9 number, 19, 13, is also relatively close to the 15, 24, 14. So what I do is I go through the entire profile to determine whether or not there's a major contributor. Yes, those numbers are higher, but throughout the whole profile, some numbers may be higher, some numbers may be lower that belong to Walter Scott or Michael Slager. So in this profile right here, there's just no way to determine a major minor.
Okay, and if we're not going to determine a major-minor contributor because we don't have that, we don't meet that threshold, you can still, from these, determine who contributed more than the other, correct?
Not necessarily. Yes, the numbers are higher, but as I say, it's relative, so it's not an exact, but it does give us an idea of how much of that DNA for that number is at that location. So just because the number is higher does not mean that necessarily that person is a major contributor. That's why we have those criteria to meet within the 60% to determine a major and a minor, not just because a number is higher at a certain location.
And I understand that. I think the question is not whether it meets the threshold, the forensic threshold, that is for the designation of major and minor, but you can tell who contributed more, can't you?
No, not necessarily.
Could we see back to the SLED case notebook, or pardon me, the SLED manual, page 135? You see the first sentence after mixtures with major minor contributors?
Where it starts with an individual, yes,
Yes, sir.
I do see that sentence.
Could you read that, please?
An individual's contribution to a mixed profile is generally proportional to their qualitative representation in the profile. Distinct differences in the contribution of one contributor versus one or more contributors to a mixed profile will often allow the major profile may be extrapolated and treated the same as a single source profile. When distinguishing a major minor contributor, the entire profile must be considered.
Okay, so that tells us that, doesn't it, that you can get real distinct differences where you can go major, minor, but that the bottom line is the individual's contribution is proportional to that quantitative representation.
Yes, but as I stated, it needs to fit the criteria that is necessary to determine a major or minor. Just because, like I said, the number is higher, does not necessarily mean that that person contributed more DNA to that item.
Well, then what would that first sentence mean if that's not the case, that it's proportional to the quantitative representation?
To me, what that statement means is that basically it is proportional, but based upon, because you can't just take that sentence as it stated. You have to read the whole paragraph as it stated, and we have to use the criteria that are necessary to determine a major or minor. We just can't take one sentence from this whole thing and be able to say that because of that, there's a major, that we have to take the whole thing in its entirety.
I understand. Mike, it's true that you can identify a major and minor contributor in these items, right, in some cases?
In some cases.
And it's true that the representation of quantity, the individuals, it's proportional to their representation of quantity, correct?
Yes, that's correct.
And if one were to look at the peaks again on item 27, and at almost every STR, the contribution as measured in RFUs by Walter Scott was greater than Michael Slager. Isn't that correct?
I would have to review the profile again, but as I stated, because the numbers are higher, that does not necessarily determine a major. It has to fit within the criteria that we have to determine a major or minor. That's just not the way it works by picking the higher number and saying that's a major. That's not how the science works, and that's not how you determine a major at a profile.
And I'm not trying to determine a major. I'm just trying to determine who contributed more, not a major.
Still, I can't say that, because how we determine, how we break down a profile is major or a minor, not who may have contributed or who may have a higher value of a number at a certain location. That's just not how we determine or read the science.
So it's not forensically significant to you that one person's peaks are higher all along, and that represents the quantity of the DNA?
Not if it does not fit into the criteria that we set forth to determine a major or minor.
Okay, thank you. Now, we've gone over the items that you have reviewed on the items that you have reviewed that were sent to you by SLED. Did you get any fingernail clippings from Michael Slager to analyze?
No, I did not.
Could it have contained important forensic information if you were given that?
It is possible.
And you were given fingernail clippings from Walter Scott, isn't that correct?
Yes, I was.
Now, you said earlier that you could ID body fluids if you were asked to do so in that DNA that was provided to you. Is that correct?
Yes, if the request is made, we can definitely test for a body fluid.
And was that request ever made in this instance?
It was for, items 23 and 24.
But not for any of the other items?
No, they were not.
Let's talk a little bit more about touch DNA. Touch DNA, you said, is DNA that, well, tell me what you think touch DNA
Yes,
is.
touch DNA is DNA that is possibly left by an individual that may have touched the item because that individual may have left their skin cells on that item.
Okay, and then you talked about secondary transfer. Could you explain again what secondary transfer is?
Yes, as I stated, if a first individual comes and touches an item and then they may have potentially left their DNA there, then a second individual comes behind them, touches that same item, now they potentially have their DNA on their hands, and then they go and touch a totally separate item, such as maybe as an elevator or button, as I explained earlier. And so potentially now that second person has transferred the first person's DNA onto that new item.
But it would be a second generation transfer, is that correct?
It's secondary transfer, that's correct.
And touch DNA, would you be more likely to find touch DNA on an object that you handled on a daily basis than one that you seldom handled?
It is possible, depending upon each person sheds skin cells differently. Some people are heavy shedders and some people are light shedders. So I would expect a person's DNA to be on something that they handle every day, but I could not say that for sure.
And you would presume, and I think correctly, that Officer Slager's Taser was handled by him every day, correct?
I would believe so.
And touch DNA, if you just touch an object, some skin cells will get on it, correct?
It is
possible.
It's possible, yes.
If there is a struggle with an object, so if there's an object being torn apart and there's abrasive action on hands, would you expect more or less touch DNA from a situation like that?
As I stated earlier, I would expect DNA there, but as I stated, some people are heavy shedders and some people are light shedders, so it just depends upon that person that's handling the object.
And would it depend on any abrasive action caused by perhaps a struggle?
Yes, I would believe that may add more, but as I said, I could not say for certain.
Now, we talked earlier about fingerprints and DNA. Now, you said it's possible to do fingerprints and still get a DNA sample?
It is possible. As I stated, I'm pretty sure it's not the preferred method to do it. I believe the method that Law&Crime does, which I'm not trained in anything, but I know that they have methods that could degrade or break down DNA. So it would be not the most easiest thing to get DNA and fingerprints from, but I know it is possible.
And it was not done in this case, correct?
No, it was not.
And did you know that the end of the taser was not swabbed by the technician?
No, I did not know that.
Do you think they're, given the explanation you gave on touch DNA, do you think it would have been important to have DNA from the end of a taser that might have touched someone?
Yes, it is possible that it could have been beneficial, but I'm not exactly sure which end of the taser.
I'll show you. This is the end of the taser for a drive stun that would administer the electrical charge.
Okay.
And this area was not swabbed. Do you think there could have been useful information from this area based on your experience and knowledge of touch DNA?
It is possible.
Now, you talked about secondary transfer. In your experience, can there be more DNA after a secondary transfer than there was on the initial?
It is possible. I could not be sure. As I stated, people shed differently. So it's possible that it could be more or it could be less. It just depends upon how much DNA is there and how much DNA got transferred. The distance between the transfer, it's a lot of variables that will go into it.
Now, there were no fingerprints taken in this matter, and there's no secondary transfer for fingerprints, right?
I'm not a fingerprint expert. I'm not sure about that.
I have a moment, Judge. Thank you very much.
No problem.
Let me redirect.
Mr. Stewart, just to be clear regarding the taser swabs, your sled item 27, is it still your opinion that you cannot determine a major or minor contributor on those swabs?
From item 27?
Yes,
That is correct.
sir. And that's because I believe the last line of the, that was put up there is that you have to look at the entire profile. It must be considered, correct?
That is correct.
And you also indicated in your prior testimony that on the swabs from the taser, it was a mixture, meaning that it could be more than 2 people.
That is possible.
And in fact, if you can refer to page 5 of your report that Mr. McCune showed you, on 4 of the 16 spots on your chart, there appear to be numbers unrelated to either Mr. Scott or Mr. Slager. Is that correct? I believe if you look at your 5th column, your 7th column, your 8th column, and your 10th column.
I'm sorry, I only see 3. Which ones you were saying? I'm sorry.
The column is D3S1358, that's your 5th column.
D13 and D19.
So on those spots where you see another number that's not related to either Mr. Scott or Mr. Slager, that's what indicates you that it could be another person, a mixture of
It could be another.
I'm sorry. That's what indicates you it could be a mixture, including another person.
It could be a minor third contributor. That's correct.
And combining that with your explanation of what touch DNA is and DNA transfer, considering the whole taser was swab, that could be from someone else that handled the taser or that had Mr. Slager and Mr. Scott had touched before that, correct?
That is possible.
And it could be from somebody that handled it or somebody else that may have been tased, correct?
That is possible.
Court's involved. I see that report that Mr. Farr. This time, we'd like to, because there's been so much testimony about it, introduce or mark this as state's exhibit. It was previously marked as defendant's exhibit.
Heard you saying something. Were you speaking to me?
Yes, sir.
Okay, what'd you say?
It's been marked as defendant's exhibit. We'd like to mark it as a state's exhibit admitted in evidence at this time.
Any objection?
No objection.
It's admitted.
That'd be states 244. No further questions.
Anything further?
Briefly, Your Honor. Mr. Stewart, we had talked earlier about alternate ways of swabbing the taser. It's certainly possible that had the taser been swabbed in smaller areas rather than all over the taser with both swabs at the same time, it would have been possible to find a major and minor contributor for those areas. Isn't that correct?
Yes, that's potentially possible.
And a moment there. Your Honor, I think there's objection. The defense would like to admit the laboratory report that was done by Mr. Stewart. It's marked as, and I'm sorry, may I take a look at that? Defense
I don't have the report.
exhibit.
I don't have the report, I just have the
Yeah.
case file. Okay.
And what's the proper nomenclature, sir?
The case, my
Case
case file.
The defense would like to admit what's been marked for identification as Defense Exhibit 27, the case file, for the jury to produce that resolution.
On what basis?
On the basis that the testimony of the scientist, that this is his work product, that this is what came out of the work
Well,
product.
let me ask you this, under what provision of the rules of evidence?
Your Honor, I believe it's a scientific test or experiment that was relied upon or produced by him, and I think it's relevant to the jury's consideration of the testimony that was been presented. It's very hard to keep in your mind the pictures that were...
Under what provision of the rules of evidence? Under what rule of evidence?
Your Honor, under the same provision that the state admitted that the court admitted the previous report.
Rules have numbers. Under what rule of evidence?
This moment.
All right. Ladies and gentlemen, we'll take a break now, and as we talk about a rule, and we'll have you come back for a while. Testimony.
And Your Honor, under the hearsay rule, this is a recorded recollection of the work that the analyst did on this item. And it also, under Rule 705, it has the underlying facts and data that he used to reach his conclusions.
Says the state.
Regarding 705, I believe 705 says that he can testify without first testifying to see the underlying facts of the data. I don't believe that gives a reason for those to be admitted. The state's position is that under Rule 403, excuse me, although it may be relevant, it could be excluded because the risk of confusing the issue and misleading the jury, in this case confusing the jury, even in walking Mr. Stewart, who's an expert in the area, through each individual spot on the charts, graphs that Mr. McCune wants to admit, becomes confusing. So we believe that having that whole package go back to the jury is just going to be confusing and misleading to them, so we would ask that be excluded under those lines. And he's testified to the substance contained in that
response?
Your Honor, I believe it, even under 403, it would be probative. I believe it's something that the jury can take for what it's worth. Mr. Stewart actually did a very good job of explaining to the jury what these numbers represent, and they can take of it as they will. I don't believe it would be confusing, particularly based on his explanation. I trust the jury can make a proper determination to the weight they would give this evidence if it were permitted to them. And to be quite frank with you, Judge, I can't imagine that they will spend a whole lot of time poring over the document, but I do believe it should be available to them.
Yes, sir.
Your Honor, also it's become cumulative, the idea that Mr. McHugh was discussing those numbers with Mr. Stewart. Mr. Stewart's indicated on direct as well as on cross and as well as on redirect that he's unable to determine major or minor contributors shown 27. Despite being shown various points on the graphs, when Mr. McHugh tried to get him to say that, he's steadfast held to it's no major or minor contributor. So that's why we believe that the admission of those items were just numbers, raw numbers in circles of a graph would be misleading to the jury.
Yeah, Mr. McKinnon contends in his argument in part that the report is a recorded recollection as an exception to the hearsay rule. Recorded recollection under Rule 803-515 says a memorandum or record concerning a matter about which a witness once had knowledge but now has insufficient recollection to enable the witness to testify fully and accurately, shown to have been made or adopted by the witness when the matter was fresh in the witness's memory, and to reflect that knowledge correctly. If admitted, the memorandum or record may be read into evidence, but may not itself be received as an exhibit unless offered by an adverse party. I believe that to admit the entire file of his record would be cumulative. There's no indication that it has any impeachment value based on the arguments made, and I find that it would be cumulative, and I sustain the objection to the admission of this document into evidence.
Okay, thank you, Judge, and thank you for noting our exception.
And per the rules, exceptions don't have to be noted. They're part of the record. Once offered and the court rules against the party, it sounds good, but it's not necessary. Okay, we'll take just a few minutes.